Okay, let's go on the record. I'm sorry, we're not going on the record, but we're going to start the Allen v. Eland Energy case. Let's go ahead and proceed.
Good morning, Your Honor. Ben Barnes on behalf of plaintiffs Carol Allen and Hunter Allen, who are co-trustees of the Allen 2018 Family Trust. Judge, we filed an application for appointment of a receiver after learning that our partner and our fiduciary has for years been commingling funds and potentially using jointly owned assets to finance his own personal investments. And we're here before you this morning on a motion for expedited discovery to assist us in preparing for a receivership hearing that we'd like to have set just as soon as possible. And Judge, I know you've had a long morning, but I'm hoping that you'll indulge me so that I can give you some background facts that kind of illustrate a little bit more clearly why we're here this morning and seeking the relief that we're seeking.
I have a lot of hearings. Just do it quickly.
Yes, sir. Would you mind giving me permission to share my screen, Your Honor?
You already have it.
Okay. So Judge, just briefly, I'd like to orient you to the parties. So as I mentioned, I represent Carol and Hunter Allen, who are co-trustees of the Allen 2018 Family Trust. And they're related to the defendants, which are E Holding Limited Partnership and Eland Energy, and that they're the 50% owner of those entities. And we're here, Judge, because there are really three key facts that are uncontested in this case. Now, that's that Greg Allen, so going back to the org chart here, Greg Allen, this is Carol's brother-in-law and Hunter's uncle. He's their 50% partner in these businesses. Greg has exclusive control over both Eland Energy and E Holding. So you'll see here, Judge, that Greg Allen, he's the president of Eland Energy, and he's also the executive director. It's like a chairman role. And Eland Energy is also the general partner of E Holding. The reason for this, Judge, is that these businesses were started back in the 1980s by Greg Allen and his brother, Tim. Tim has since passed away, and his interest passed on to his heirs, including Carol and Hunter. And that interest is now held by the Allen 2018 Family Trust. Before Tim passed away, Greg agreed to take on control of these businesses and to manage them for the benefit of his heirs. And so for the past 13 years, we've trusted that he did that, not only because, like I said, he's Carol's brother-in-law and Hunter's uncle, but also because he's our fiduciary, right? He's the sole controller of Eland Energy that we own half of. The other key undisputed fact, Judge, is that Greg has been commingling Eland Energy's funds with his personal assets. And surprisingly, this is actually undisputed in this case. So as I said, for the past 13 years, we've felt and we've trusted that Greg was managing these companies in our best interest. We had no reason to believe that there was anything going on. Well, about a year ago, we received a tip from a whistleblower. A former employee of Eland Energy left the company, and he called Hunter Allen and he said, there's a problem. Greg's commingling funds, and he's using Eland Energy funds to finance his own personal investments. And it's damaging your side of the family, the Allen 2018 Family Trust, to the tune of about $20 million. So after learning this information, Hunter and Carol took a more active role in these investments and decided to investigate. And that culminated in Hunter taking an appointment as a joint trustee of the Allen 2018 Family Trust last December and sending Greg a books and records request in December of 2020. Now, a few weeks later, and this is getting to the point that Greg's actually confessed to commingling funds. A few weeks later, Greg had his director of accounting, a guy by the name of Derek Smith, send us an interesting message. And the message to Hunter was that, look, I know you've been recently appointed as a co-trustee, and I'd like to disclose to you a historical practice of the owners of Eland Energy. He said, as you may be aware, it's been the historical practice of the owners of Eland to use Eland's bank account as a clearinghouse of sorts for personal investments. In other words, Greg has been using Eland's bank account and commingling his own funds with jointly owned assets. Now, before, and by the way, this email was to both Hunter and Carol, Judge. Before Hunter received this email, he never knew of this, quote, historical practice. I mentioned that Hunter very recently took appointment as a co-trustee, but Carol has been a trustee holding an interest in this company for 13 years, and she's never heard of this historical practice either. And the message goes on to say, currently there's a balance attributable to the Tim Allen Q-Tip Trust. In other words, the company has accrued a payable to the Tim Allen Q-Tip Trust of $10.7 million. Now, there are several problems with this disclosure, Judge. The first relating to timing. So again, this email was sent on January 5th. And Mr. Smith couched this as saying, I'm introducing you to the business of Eland, Hunter, as a new co-trustee. Well, the problem with that is that Hunter was appointed as a co-trustee in early December. Mr. Smith and Eland Energy knew that, and yet they waited a month to make this disclosure, which is a very material disclosure, being that we, the company, are holding nearly $11 million of your funds. The other problem with this email, Judge, and the reason it raises red flags, is based on the timing of the accrual of this liability. So you see in the bottom snippet there, it refers to the Tim Allen Q-Tip Trust. Well, you may have noticed that that's not a party to this litigation, that trust. And the reason is that the Allen 2018 Family Trust, who is the party, they acquired the Q-Tip Trust's interest at the beginning of 2020. In other words, Eland Energy has had this liability to the Q-Tip Trust for at least 2 years, and we suspect even longer. So there's no excuse for this delayed disclosure. It's not like there was an asset sale or some other transaction that could have caused this liability to accrue within the last 2 or 3 months. The other problem, Judge, is of course the amount of the funds. We're looking at $10.8 million in accrued liabilities from the company to our clients that they had no idea existed until they received this email on January 5th. At the same time, Mr. Smith, again, Eland's director of accounting, he sent a similar email to Carol Allen disclosing that the company had a similar liability that had accrued to Carol individually for $5.7 million. And this bears the same problems, Judge. And again, the reason that this liability is to Carol individually and not the 2018 Allen Trust is because, like the Q-Tip Trust, Carol used to be a shareholder of Eland Energy, but she assigned her interest at the beginning of 2020. So the company's had this liability to Carol for at least 2 years. So essentially, after we issued a books and records request in December, and after we re-urged that request on January 4th, after Eland indicated that they would refuse to produce their general ledger and their bank statements, we learned that the company has been holding $16.5 million of our funds. Now, Eland's made much of the fact that this arrangement, as they refer to it, was disclosed in the company's financial statements. There's 2 problems with that, Judge. The first is that Eland never disclosed its financial statements to anyone on the Allen 2018 Family Trust side, that is Carol or Hunter, until after we made the books and records request in December. But I'd also just like to read to you from the financial statements, because this is the extent of the disclosure concerning this accrued payable that's contained within the financial statements. The financial statements say the company had a payable due to various related parties of $15.7 million as of December 31st, 2020. So that's been the extent of this disclosure prior to this point. Now, at the same time, Judge, we exhausted the resources that we had after Eland refused to produce their general ledger and their bank statements. We exhausted the resources that we had, and we sought information from other parties. So among those were our own tax accountants.
I'm so sorry. You got to get to the point here. So what do you want me to rule on? If you want to reschedule this hearing, I'm happy to do it, but I have a number of other hearings behind you. And so ask me what you want me to ask you. What do I need to rule on? And I've gotten enough background. So, but I'm happy to reschedule this if you need more time.
I understand, Judge. I hear you. I think you've gotten the point. What we're asking for is very narrow expedited discovery that goes towards our very narrow request for appointment of a receiver. So to orient you, Judge, we've asked for a receiver.
I get it.
Not to take over control of Eland Energy. We've asked for a receiver simply to go in and take control over the accounting functions and conduct an accounting so that we can understand what happened. Our discovery requests are focused on that request for relief. And all we're asking the court to do is order Eland to disclose its general ledger, Eland and E Holding, to disclose its general ledger and to disclose their bank statements. That's it, Judge. And in terms of the exigency, that's why I was giving you that factual background.
I get it. Response? Anybody want to respond?
I do, yes, Your Honor. We might need more time simply because what he said at the end is that he says he wants a narrow relief of a receiver. That's not a narrow relief. And he says he wants narrow discovery. He's not asking for narrow discovery. He's asking for very broad discovery. But Your Honor, the bigger issue, and by the way, he's not asking for a receiver just to look at the accounting. That's not what he's doing. And Your Honor knows from the 5-star case that you can't have a receiver just to look at the accounting. That's inappropriate.
Yeah, that's exactly right. I was going to bring that up. So what?
Your Honor, the biggest issue, and if one does, I'd share my screen, but I'll just tell you, the big issue that we have is what's the fire here? What's the emergency? And I can walk you through. I've got a PowerPoint.
Well, it sounds like your client is allegedly commingling funds in a corporation. That seems pretty like an emergency.
Your Honor, we can explain it all, but let me give you the facts. So I want to highlight that Mr. Barnes said a number of things that are not supported in the record. He says a number of things what his clients knew or didn't know. There's no declarations from his clients whatsoever in the record, none. What is in the record is a declaration from my clients talking about the company at issue. And just for you, and I'm going to give you some background too, because it sounds like we haven't given them any documents at all. They sent us a books and records request in December 20th of 2000. This is over 6 months after they learned of this issue about the commingling. So they learned about the commingling, they say, back in early 2021. That's what they allege. Then they wait. I don't know what early 2021 means. We haven't done any discovery. In fact, Your Honor, we haven't even answered this case. That's our problem. We haven't answered the case. Our answer date is the end of February. So they say, hey, we found out about this in January or February of 2021. They wait until December 20th, 5 days before Christmas, to send us a books and records request. You know what we did? We pulled together 2,000 documents over the holidays and gave it to them. And it's the documents they asked for. They made a list. There's 109 entities. There's 19 categories. We produced tax returns. We produced audited financial statements for the companies that they now seek a receiver for. So we've given them a lot of financial documents. And then we also gave them the deal documents that these entities have engaged in over the last decade or so. To buy and sell property, they have those documents. They have audited financial statements. They've got tax returns. So we're down here going, what's the rush? What's the rush? So then we put an affidavit in the record, Your Honor, that's there. And let me just highlight some of this. Based on audited financial statements, so this is all sworn to in the declaration. The audited financial statements show that the entities that they're seeking a receiver for have consistently satisfied outstanding liabilities while substantially growing the net income. The 2019 and 20 audited financial statements show that defendants' outstanding liabilities equaled approximately 25% of their total assets. So they've got 4 times more assets than liabilities. As of February 7, 2022, E Holding and its wholly owned subsidiaries, including Eland, have cash on hand that is more than double their long-term debt. So they're sitting on cash. And this is after paying his clients $17 million. So I hope you didn't catch the irony of what they're really complaining about is that they got $17 million recently. So we paid them $17 million. And despite paying them $17 million, we have cash on hand that's more than double our long-term debt and 15 times greater than the 2022 debt service requirements. We own real estate worth over $120 million. And there's testimony in the record that we don't expect to have any financial difficulties. We've never had financial difficulties. We're a very solid, stable, operating company. And so for them to say, oh, we need a receiver, it's wholly inappropriate, but especially it's not urgent. So we're basically down here, Your Honor, on a motion to compel without even having answered the lawsuit. And there's just no emergency. And so as we argue in our response, they have to show.
So let me ask this. What is the emergency?
Judge, the emergency is that we've learned that our fiduciary is misappropriating company assets. Insolvency is not the only reason.
Sounds like you learned that over a year ago. Is that right?
That's not true, Your Honor. We've confirmed that in spite of the defendant's ongoing refusal to provide us information. I appreciate Eland's efforts to produce some documents, but we have made it clear from the get-go that our priority was the general ledger and the bank statements. And I can't think of any reason why a company would refuse to provide those to their 50% shareholder. And I appreciate the affidavit that Mr. Stammel read from, but let me take that witness's deposition. Let me examine the general ledger. And if he's right, then that's great. But the problem, Judge, is that we have very clear evidence that a fiduciary has been misusing company funds. I think in my presentation earlier, Judge, I think the most compelling fact that I left out in summarizing that was that we know that in 2016, Greg Allen caused Eland Energy to loan $31 million to Tim Allen, who had passed away 8 years previously. We know that from documents that we've received from other parties, in spite of Eland's refusal to provide us with the basic documents, which are the general ledger and the bank statements. It's untenable to me.
So let me just ask this: why can't you produce the general ledger and the bank statements? That's what they're asking for.
Okay, so I hope you didn't miss the fact that he's complaining about something that happened in 2016 right there, and can be explained. But the general ledger, as it said in our declaration, has 45 million entries on it. The bank statements are seeking are for 8 years. This has nothing to do with whether a receiver can be appointed today. As Your Honor well knows, in order to appoint a receiver, there has to be an existing emergency. There's got to be some kind of melting ice for a receiver. What they're complaining about is stuff that happened in the past, and that if they want to bring a breach of fiduciary duty claim, they should, but we shouldn't leapfrog or hopscotch, whatever you want to call it, the normal discovery process. We're down here on a motion to compel where they're seeking 48 million lines of accounting entries. It's so far beyond anything that they need in order to pursue a receivership claim, but there's no urgency.
Judge Hoffman, we've offered several times to have an independent third-party forensic accountant go in and manage the transfer of that data.
If we want to go,
I mean, it's really, there's no burden to them whatsoever.
Well, I'm not arguing verdict. It's 48 million accounting entries that they're not entitled to. They're very clear. They said this is not a books and records case. This is a receivership case. Well, a receiver doesn't need all that stuff. Nobody needs to know all that information in order to determine whether a receiver should be appointed. Your Honor, I've cited the law. I can go through the law. Excuse me, Ben. I can go through the law with you. And Your Honor, I think you know it. It's like in order for a receiver to be appointed, the plaintiffs need to show that there is some imminent danger to the company or to the owners of the company, and that's just not the case. What we have here is what they're alleging is essentially a breach of fiduciary duty. And if they want to try to show a breach of fiduciary duty against Greg Allen for his management of Eland, they can do that. But there's no emergency. They've trumped up this, we need a receiver, and so we need these documents really quick. But they don't need them really quick. We've got plenty of money. It's sitting there. That's what the declaration shows. So if they want to pursue damages, great. But they shouldn't be able to make me turn over a tremendous volume of documents prior to my answer date. And Your Honor, if you want to, I do think if you're going to indulge any discovery at all, I would ask for some more time so we can actually go through their requests and figure out what they might need in order to determine whether there's a receivership. But what they've asked for right now is way too broad. And I'm trying to really truncate my argument given your schedule. But
no, I appreciate that. So 2 points I would make. One is that I do agree with Mr. Stammel that based on the recent decision out of the Dallas Court of Appeals, which came out of my court, it sounds like you need the appointment of an auditor as opposed to a receiver, because you want to basically audit the books and records of the company. I did something very similar in a case, and I called it a receivership, and the Court of Appeals kind of said, hey, that's really not what this is. They were very nice about it, but said it really should be more of an auditor. Is that kind of what you need more than a receiver? You're not trying to take over the company. You just want to look at their books and records.
Judge, we're not trying to take over the company.
So read that opinion, Mr. Stammel, if you could share it with them, because I think it will help define this. And it's a very recent decision. No one's fussing with you don't know. I guess I just don't see what the problem with is turning over if all you're looking for is the general ledger, and how much in bank statements are you looking for?
We've requested from 2014 to the present, Judge.
I mean, could we just agree, Mr. Stanwell? Maybe you guys would need to talk to your clients about this. Why don't you guys just agree to the appointment of an auditor, and we don't have to go through all of this, and the auditor can do all of this? It seems like this is exactly the kind of case where you would need an auditor. I'm not saying I'm ruling on that today, but it might short circuit some of this stuff. You just agree to the appointment of an auditor, let the auditor look through all whatever they need. You say the auditor doesn't need it, the auditor might need it. Maybe you guys can discuss who you want the auditor to be.
Would the auditor report to the court, Your Honor?
Yeah, of course. The auditor report always appoints to the court.
Yeah, an agent of the court as opposed to an agent of one of the parties.
Yeah.
Okay. Well, Your Honor, we certainly can talk about that.
Why don't we do this? Why don't you guys, we'll reset you to Monday, give you a chance to talk about, I mean, what makes sense to me, I understand what both of you guys are arguing. This does seem a little premature, but I do understand commingling of funds always raises a big red flag, and you guys admitted to commingling the funds. So that's a big concern, but they did kind of wait to get here to do that. And so I would recommend, this is not a ruling, that you guys agreed to the appointment of an auditor, maybe discuss who you want it to be. I've used a guy named Jim Smith in the past. I don't know how extensive these documents are. He's kind of he's done a good job in other cases, but if there's someone else you want to use, you can do that. He's with a accounting firm called Smith Bolliard, and he's doing another major auditing job for me right now. So you might want to get somebody else, but that's what I would suggest. If not, then we can discuss this, but it just doesn't seem necessary to do this. But I also understand where, I keep forgetting your name because it's not up here, Dallas.
It's Ben Barnes, Your Honor.
Mr. Barnes. Mr. Barnes is saying is that we're gonna need these documents eventually. I tend to think probably the auditor will need some of these documents. That would be my suggestion. So what time can you guys come back on Monday or Tuesday, or what's
Your Honor, the only thing that I feel like we might need a little more time on is to discuss and consider and probably argue about the scope of the auditor, because where I'm sitting right now, I feel like I just got to this case, and now all of a sudden there's going to be a whole floodgate of discovery open without any sort of process that you typically get in a typical civil case. So I think we need to have some parameters, and I think Mr. Barnes and his client need to set out what they have in mind for an auditor. And if it's a narrow audit scope, like they say, they just need narrow things.
How about we rehear this next Thursday? Would that give you enough time, Mr. Barnes, to come up with a proposed auditor order?
Judge, I'd like to just go forward on Monday. I really don't think it's that complicated. I would have more sympathy for Mr. Stammel's position in a normal case, but we're the 50% owner in this business, and I'm not sure what kind of process we need to go through before we conclude that this information needs to be turned over to the 50% owner of the business. In other words, there's no responsiveness review should take place, and to the extent one needs to take place, because there are transactions in these documents that are unrelated to the company, well, really that's relevant to our allegations and further indicia of mismanagement. So I guess I just don't understand why there needs to be any further delay, and I'm happy to reconvene on Monday, Judge.
Your Honor, it's not delay. It is trying to understand the process and what happened. Because what they're saying, while they call it limited, it's not limited. They want documents back 8 years. There's statute of limitations issues to consider. There's other issues to consider. And if all they're seeking is receiver, right? So they're very carefully not saying breach of fiduciary duty against Mr. Allen. So if they're only seeking receiver, my position is they may be entitled to discovery about whether there's some insolvency issues or whether there's some other issues that plague this company. But that's it. Because all of the cases, Your Honor, there are so many cases where receivers.
I know. I agree. It should be an auditor at this point, but I think an auditor. I mean, my thoughts on this is an auditor can be a precursor to a receiver, but I mean, All right, we're just going to reschedule this just from the court standpoint. I'm going to reschedule this to Thursday at 9:30. We'll send you a Zoom link. And between now and then, and Mr. Stammel, I want to make this 100% clear to you. If you show up on Thursday and you two haven't conferred on this, that is not going to be an excuse to reset this again. This is going to be, we're going to decide this issue. Either I'm going to order some discovery or all the discovery, or I'm going to do an agreed appointment to it as an auditor, which I think is the more appropriate way to do this. But don't.
Your Honor, I hear you, and I agree. I would ask you to have Mr. Barnes send me a proposal for the auditor's scope on Monday, and then I will respond to it certainly before the hearing.
I would highly recommend that, Mr. Barnes, and I encourage you to read that case too, because I think it gives some really good analysis on this exact topic about when you do a receiver, when you do an auditor, when you do a special master. I don't think we need a special master at this point, but it does do a very good, the Court of Appeals does an excellent job of kind of delineating what is appropriate in certain circumstances. And it feels like an auditor's kind of what the appropriate remedy is. And so I'd urge you to read that case between now and then. We'll see you guys next Thursday at 9:30.
Thank you, Your Honor.
Thank you, Your Honor. Judge, do you happen to recall the style of that case?
I can get it to you then.
Mr. Stammel is going to provide you a
All
copy.
right, thank you.
Okay.
Thank you, Your Honor.
We have a ton of people here. Have I missed anybody that's anybody here on the scheduling conference docket? Anyone here on Klein v. Klein?
It looks like almost everyone's here on that case.
Okay. All right, let's go on the record, Tony, on DC 201129, Klein v. Klein. Counsel, make your appearances.
Chase Linser, Your Honor, on behalf of Great American GMAC.
If there are no other attorneys, then David Gibson on behalf of William Robert Klein Jr.
Let's proceed.
I'm sorry, Judge. Can I get the first counsel's name again, please?
Yes, Chase Linser, and that's L-I-N-C as in cat, E-R.
Thank you.
Let's
You're
proceed.
welcome. Thank you, Judge. We're here today on our amended motion to enforce an agreed judgment. Specifically, the agreed judgment is one that was signed last year, May 11th, 2021. It was regarding a piece of property in Dallas, Texas. Under the terms of the agreed judgment, you signed an agreed order stating that the property was to be sold, and the parties who held interest in the property were to cooperate fully with each other in the sale of said property. Now, after the agreed judgment was signed, the defendant, William Robert Klein Sr., transferred his 1/3 interest in the property to his son, William Robert Klein Jr. It is my client was hired by the 2/3 interest holder to broker a deal to sell the property. My client has lined up multiple offers from individuals in order to purchase the property. Mr. Klein Jr. has put up blockades on trying to sell the property because he has stated that he wants to buy the property, but has never submitted a formal offer until this morning, about an hour and a half before the hearing, for the 2/3 interest holders to review. It's our view that the transfer of the 1/3 interest to Mr. Klein was in direct violation of the agreed judgment order. But we're here today. We want to have the court order an enforcement of the agreed judgment to Mr. Klein Jr. as the current 1/3 interest holder on the property. Our client has multiple offers on the table. Now that Mr. Klein Jr. has submitted an offer, it's up to the parties to come to an agreement as to who the property is to be sold to. There's no law or language stating that it has to be sold to Mr. Klein Jr. He is a competing offer here. There's no, and we just want to ensure that Mr. Klein Jr. cooperates fully with the agreed order that this court signed last year on
Okay.
May 11th.
Mr. Gibson?
Judge, this motion is not half-baked. It is still in the box on the shelf in the grocery store. GMAC is not a party to this lawsuit. None of the movements on this motion are parties to this lawsuit. William Robert Klein Jr. is not a party to this lawsuit. I was focused on the substance yesterday, and then it occurred to me, literally no one on this motion is properly before this court. It should be denied without further consideration.
Judge, if I may explain real quick.
Okay.
By Mr. William Robert Klein Sr. transferring his interest to his son, Klein Jr., even though it may have been in violation of the court's agreed judgment, Mr. Klein Jr. now stands in the shoes of his father.
I agree
and
with that.
should be held to the same standards.
And
that
I
his
guess I'm
father
a little
is.
confused. Who do you represent, Mr. Linser?
I represent Great American GMAC. We are a beneficiary to the agreed judgment that you signed because my client was hired by the 2/3 interest holders to sell the property as agreed to in the agreed judgment.
So not a party to this lawsuit, Judge. They have no standing to do anything.
You don't represent, did your client, I guess you said assigned it to GMAC? Is that what happened? I'm a little unclear.
No, Richard Klein, the plaintiff, has since passed away, and on the agreed judgment that was signed, the executrix of his estate, Tara Smoot, signed the agreed judgment on his behalf since he was deceased. And she has, as the 2/3 interest holder for Richard Klein's estate, has hired our clients, GMAC, to sell
So
the property.
are you proceeding on behalf of the executrix?
We do not represent the executrix, Your Honor. We represent Great American GMAC.
All right. So I do tend to agree with Mr. Gibson that this probably isn't properly brought. This needs to be brought on behalf of the executrix, and I don't really think this is the right procedure. What makes sense to me is that if you guys can't reach some kind of agreement, and hopefully you can, is that you would make a request to appoint a receiver to
And
sell
Judge,
the property, and that would be my suggestion. But I think at this point, I think Mr. Gibson is right.
if I may, real quick, Judge, Tara Smoot is on the call right now.
Right, but she didn't bring this motion, correct?
Correct.
Correct.
Yeah, so she would need to bring the motion. I don't agree at all with Mr. Gibson that his client isn't the right defendant, because you can't just get out of an agreed judgment because he shouldn't have ever conveyed the interest. I'm not even sure that's legal at this point. So I don't agree with Mr. Gibson on that, but your client needs to bring the motion. I don't think this is the right motion anyway. I think it needs to be something like, I mean, the way to do these, and it should have been done in the original order, but is to have some mechanism. The only way I can have that I can think of have any type of enforcement is say, hey, we need a receiver to do this. We'd hire a real estate agent to sell it, and they would help to make a determination of what is the best bid. But I agree with Mr. Gibson at this point, this case, that this motion isn't properly brought. So I'm going to deny the motion. Anything else, guys?
No, sir. Have a great weekend, Judge.
Just go ahead and submit an order for me, Mr. Gibson. Make sure on the order at the beginning it says this was heard on February 18th, 2022. You email a copy of the order to Mr. Linser, and then forward it to Rhonda, my court coordinator, as well as e-filing it. But make sure at the beginning it does say this was heard on February 18th.
Absolutely. Will do, Judge.
All right, guys. Good luck.
Thanks. Take care.
Thank you, Judge. Have a good weekend.
You too. I think we're back to Couch v. Turner Massey. Did you guys work everything out?
Well, Your Honor,
Go ahead.